Constitutional Court Interpretation Number 744, Prior Restraint on Commercial Speech Case. Issue Article 24, Paragraph 2 of the Statute for Control of Hygiene and Safety of Cosmetics and its punishment, as provided in Article 30, Paragraph 1 of the same statute, unconstitutional. Holding Article 24, Paragraph 2 of the Statute for Control of Hygiene and Safety of Cosmetics reads, before publishing or broadcasting any advertisement, the cosmetic firm shall first submit the content of advertisement to the health authority, to central government, or that of a special municipality for approval. Article 30, Paragraph 1 of the same statute reads, any person who violates Article 24, Paragraph 2 is punishable by a fine up to 50,000. These two provisions constitute a prior censorship of cosmetic advertisements and go beyond what is necessary in restricting the cosmetic firm's freedom of speech. As such, they are not in accordance with the proportionality principle as acquired by Article 23 of the Constitution and violate the people's freedom of speech under Article 11 of the Constitution. These two provisions shall be null and void immediately from the date the announcement of its interpretation. Recently, this case was petitioned for by DHC Taiwan, Inc., whose representative is Yoshida. The petitioner advertised its sunscreen lotion products on an online shopping website without first applying for and obtaining approval from the competent authority. And this court made this interpretation on the basis of the following grounds. The purpose of freedom of speech is to ensure the free flow of information, to provide people with opportunities to obtain ample information and to pursue self-realization. Cosmetic advertisement promote the use of cosmetic products through media communication for marketing purposes. They are a form of commercial speech. To the extent that commercial speech is producing information for lawful business, which is neither false nor misleading and can help consumers make economically rational choices, it is protected by Article 11 of the Constitution as a form of free speech. Article 24, Paragraph 2 of the statute stipulates that before publishing or broadcasting any advertisement, the cosmetic firm shall first submit all the text, picture, or oral statement of the advertisement to the health authority of the central government or that of a special municipality for approval. For the record, the cosmetic firm shall also present the approval letter or certificate to the press or media. Any person who violates Article 24, Paragraph 2 is punishable by a fine of up to 50,000. If the violation is a serious or recurring one, the violator's business license or factory permits may be annulled by issuing authority. Taken together, these provisions constitute a prior censorship of cosmetic advertisements that restricts cosmetic firms' freedom of speech and the opportunity for the people to obtain ample information. Being a severe interference with the freedom of speech, such prior censorship of cosmetic advertisement shall be presumed unconstitutional. The provisions at issue can be otherwise regarded as permissible under the constitutional principle of proportionality and the constitutional guarantee to the freedom of speech if, and only if, the legislative record are sufficient enough to support the finding that the prior censorship of cosmetic advertisements is directly connected to and absolutely necessary for the achievement of compelling public interest in preventing direct, immediate, and irreparable harms to people's life, bodily integrity, or health, and the people are afforded with the opportunity to seek prompt judicial remedy. Cosmetics are defined as a substance to be applied externally to the human body for the purpose of freshening hair or skin, stimulating the sense of smell, covering body odor, promoting attractiveness, or altering the appearance. The National health authority is further authorized to make public the scope and the category of cosmetics. In other words, cosmetics are not for oral digestion. In addition, all of the cosmetics listed in the table on the scope and category of cosmetics as announced by National Health Authority are ordinary products for daily use. The most likely legislative purpose of the provision at issue, therefore, is to prevent obscene, immoral, false, or exaggerated advertisements from being published or broadcasted, so as to maintain bony morals and to protect consumers' health as well as other lawful interests that are deemed relevant. This has to do with the protection of public interest, to be sure, but since cosmetic advertisements are aimed at attracting consumers to purchase advertised product and do not pose direct or immediate threats to the people's life, bodily integrity, or health, it is difficult to argue that the purpose of censoring such advertisement in advance is to prevent direct, immediate, irreparable harm to people's life, bodily integrity, or health. And since the provision at issue cannot be said to be aimed at protecting any compelling public interest, there exists no direct or absolutely necessary connection between the restrictions imposed by the prior censorship of the provision at issue on cosmetic firms' freedom of speech and the consumers' access to full information on the other hand, and any compelling public interest on the other hand. According to existing law, cosmetics are divided into two major categories: ordinary cosmetics and cosmetic containing drug ingredient. Cosmetics containing drug ingredients are for such use as sunscreening, hair dyeing, hair perming, minimizing sweating and odor, skin whitening, acne prevention, skin moisturizing, preventing bacterial infection, teeth whitening. Although they could produce greater impacts than ordinary cosmetics on people's life, bodily integrity and health, it is inconceivable that their advertisement would pose direct threat to people's life, bodily integrity, or health. Besides, regardless of whether it is imported or produced domestically, a cosmetic contain drug ingredient could be imported or produced only if it has first applied for and then obtained approval from authorities after examination and testing. Any cosmetic containing drug ingredient must list the ingredient usage dose and other information as required by National Health Authority on its label, leaflet, and packaging in the same manner as what is required for any ordinary cosmetics. Also, it is required to disclose the name and the content of drug ingredient content, the precaution for use, and the serial number of its license. As far as for the prevention of health hazards is concerned, Chapter 4 of the statute authorizes the Health Authority to conduct such inspection measures as spot checks and sampling, and to enforce the law by revoking the licenses and prohibiting the importation, manufacturing, and sale. Chapter 5 in turn provides for the penalty for violation. Furthermore, Article 24, Paragraph 1 of the statute bans false advertisement and the like, and the authority may also invoke Article 30. Paragraph 1 of the statute to punish those false cosmetic advertisements that are likely to be harmful to human health. Given the above regulation and the subsequent punishment, the provision at issue, even when applied to advertisement for cosmetics containing drug ingredient, can neither be justified as pursuing any compelling public interest nor be directly connected to and considered absolutely necessary for protecting any such interest. In sum, the provision at issue violates the proportionality principle under Article 23 of the Constitution and the freedom of speech as guaranteed by Article 11 of the Constitution. Both provisions shall be null and void immediately from the date of announcement of this interpretation.